Just imagine for a second, your mother and a court order legally bars you from having any contact with your own daughter, indefinitely. It sounds like something from a movie, but it's the very real situation at the heart of a case that pulls back the curtain on the incredible tensions inside the system that's supposed to protect kids.
A de facto termination of parental rights. This phrase, it's powerful, right? It's pulled directly from the mother's legal appeal, and it just says it all. While the court didn't formally terminate her rights, the end result was exactly the same.
And this document you're looking at, this was a huge step on that path. The final order came down later in the year, giving the father sole custody and stopping all contact between the mother and child. So the massive question is, how on earth did a family dispute get to this point? Okay, let's dive into that. First, we're going to explore the mother's side of the story, and her narrative is one of a system that failed her, of flawed procedures, and of outright discrimination. The mother, Kelly O'Neill, says her diagnosed mental health conditions, like bipolar disorder and PTSD, which, by the way, are protected under the Americans with Disabilities Act, were used against her pretty much every step of the way. And this slide right here really gets to the heart of the conflict. On one side, you have Miss O'Neill claiming the Department of Social Services didn't give her the reasonable accommodations she needed, help actually getting into the right kind of intensive therapy. She says they basically set her up to fail. But on the other side, the court found that she was given the recommendations and simply didn't follow through. But it wasn't just about her disability claims. Her appeal really hammers on this idea of due process, the basic right to a fair legal fight. She argues the whole process was messed up from the get-go. For instance, the case was suddenly thrown into court after DSS had already planned for a much less drastic approach. She also says the orders from the judge were confusing and that a super important document outlining how she could get her daughter back was mentioned but never actually given to her. As things got more and more heated, the court did something else pretty major. It issued a gag order. And this became a huge point of contention in her appeal, really pitting the court's power against her constitutional rights. Her argument is pretty straightforward. This order, which stopped her from even talking about her case on social media, was a massive violation of her First Amendment right to free speech. Her lawyers are basically saying it was total overkill. Okay, so we've heard her side. Now let's flip the coin. Let's look at why the Department of Social Services and the court felt that such an extreme step wasn't just an option, but that it was absolutely necessary for the child's own good. This whole thing didn't just come out of nowhere. Back in November 2023, DSS filed a petition based on 6 different reports, and the allegations were really serious. We're talking everything from an injurious environment and substance abuse to emotional abuse and even locking the child out of the house. As the case moved forward, 2 things really started to stand out to the court. First, the mother's own communication was described as volatile. To give you an idea, she sent over 500 texts to the child's court advocate in just a couple of months. And second, and this is so important, the child's own voice started to come through. She told her therapist she was done with her mom and didn't want to see her until she stops acting all crazy. I mean, listen to this. This is an actual quote from a text message she sent to the social worker and the child's advocate. The court records were apparently filled with messages like this, which the court saw as escalating instability and, frankly, threats. And this timeline just shows how quickly everything completely unraveled. Over just 2 weeks, supervised visits just fell apart. One was cut short because the mother started recording her daughter, which made her uncomfortable. A week later, another one was stopped because she was agitated and screaming. Then, just 2 days after that, she's caught on a doorbell camera kicking the front door of the house where her daughter was staying. It's no surprise that by April 2nd, the social worker was asking to end all visits. So you've got these 2 completely opposite stories. A mother who feels failed by the system, and a system trying to protect a child from an unstable parent. And it all crashed together in a final hearing that brought a very, very decisive end to this whole saga. And here's the thing, the final straw wasn't just about documents or what people said. On October 16th, the judge specifically pointed to her own direct observation of the mother's erratic behavior in the courtroom, which apparently included storming out, as a key reason she decided that getting them back together just wasn't possible anymore. And that final order was crystal clear. No wiggle room. The court gave sole legal and physical custody to the father. It ordered a total stop to any and all contact between mother and child, and then it closed the case with DSS, effectively ending that chapter.
Now, to really wrap our heads around how a case could go to such an extreme, it really helps to zoom out from this one family and look at the huge systemic problems facing the entire child welfare system in North Carolina.
73%. Just let that sink in. That's the percentage of child welfare workers in North Carolina with less than 5 years of experience. That kind of turnover, that constant churn, it puts a massive strain on the system's ability to handle these incredibly complex cases. And on top of that staffing crisis, you've got a funding problem. North Carolina's child welfare system gets the least state funding in the entire country. So the state's 100 counties have to pick up the slack, which creates what people call a geographical lottery. The support a family gets can literally depend on their zip code. And look, people have tried to fix things. There was a big reform effort called Ryland's Law, meant to create better oversight. But a recent report found it's still not even fully in place. The system remains a patchwork, with huge gaps in who is actually held accountable. So when you strip away all the tragic, specific details, what this case really boils down to is a fundamental legal fight. It's a conflict of competing rights that sits right at the very core of family law. And this is the million-dollar question, isn't it? The Constitution is pretty clear about the rights of parents. But what about the kids? Do they have their own separate, legally protected constitutional right to have a relationship with a parent, no matter what the other parent decides? And this slide right here lays out that legal tension just perfectly. On one side, the U.S. Supreme Court has been very clear. The 14th Amendment gives a fit parent a fundamental right to the care, custody, and control of their kids. It's a rock-solid individual right. But on the other side, federal law has never recognized a separate, equally strong constitutional right for a child to see a parent, especially if the parent with custody says no. The child's interests are definitely considered, but more as part of the family's rights as a whole, not as something the child can sue for in federal court. States use the best interests of the child standard, sure, but that's a state-level guideline, not a federally protected constitutional right. So all of this leaves us with a really tough, lingering question. In this high-stakes tug-of-war between a parent's clearly defined constitutional rights and the state's incredibly important duty to protect a child from harm, how do we make sure the child's own voice and their own deep need for family are actually heard and given the weight they deserve?